It isn't uncommon that I'm told my brother-in-law said when asking a client why a document was drafted in a certain fashion or why an account lists a specific beneficiary instead of the children equally. Although well-meaning, this advice may lead to disastrous results. Stay tuned to learn what you don't know that you don't know about estate planning.
Welcome to this episode of Your Legal Legacy with your host, Attorney Michelle Conti.
Regardless of the amount of wealth that you've accumulated, certain important distinctions apply when devising your estate plan. Be it a blended family, a child with disabilities, a beneficiary who's addicted to drugs or alcohol, even an in-law who you'd prefer not to inherit. The list is endless. But where do we begin? Everyone over the age of 18 should have a durable power of attorney for finance and healthcare, along with a living will that names someone to act for them if they are unable to act for themselves. These documents will allow whomever you choose, your spouse, a child, even your parents, to act on your behalf if you become incapacitated. The HIPAA laws are very strict, and being married to the incapacitated person does not bypass the requirements of being legally appointed as their agent. Number 2, everybody needs a last will and testament. Why? Doesn't everything automatically pass to my spouse when I die? I'm asked this question often, and the answer is it just depends. If you pass away with an asset in your name, and that asset doesn't have a beneficiary, then the asset must go through probate. And probate is the process in which a court determines permission whether or not the executor or the administrator can remove your name as the decedent from that asset. The thing with probate, it takes months, maybe even years, and it can be very expensive. And if you pass away without a will here in Pennsylvania, and you have an asset in your individual name, let's say you're married and you have kids, your spouse does not receive 100% of that asset. Pennsylvania intestacy law dictates who receives what portion of your stuff. What if your will is contested? If a party wants to contest the validity of a will, the best advice is to act quickly. If you've missed your opportunity to contest a will, and the estate has already been opened, you have 1 year to file an appeal with the court. You have to state very specific reasoning as to why the will is not valid. But if you don't act fast enough and the money's already gone, what then? Does it really matter if you contest it all? The age-old adage, nothing can be certain except death and taxes. Benjamin Franklin uttered such truth in 1789. Inheritance tax is imposed on the total amount received based on the beneficiary's relationship to the decedent. Surviving spouses and charities are the only 2 beneficiaries who do not pay inheritance tax in Pennsylvania. Kids and grandkids, they'll pay 4.5%. Siblings will pay 12%, and everybody else pays 15%. Nieces, nephews, neighbors, even your longtime partner. Therefore, the best advice that I can give you is that if you've put off planning or have never spoken with an estate planning attorney, make the call for your complimentary appointment today. I'll see you soon with more tips on creating your legal legacy.
Thank you for watching Your Legal Legacy. For more great information, visit ContiLawLLC.com.